Next up on This Week in Law, Sarah Pearson, my co-host, joins me along with Pieter Gunst and Tony Lai, who are the co-founders of LawGives. We'll talk about the changing legal profession. LawGives helps you connect lawyers with clients. We'll talk about their infrastructure and technology, a legal standard of care, taking information to knowledge to wisdom, and a very unwelcome cup of tea. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
It's time for TWiT's annual audience survey, and we want to hear from you. Please visit twit.tv/survey and let us know what you think. It only takes a few minutes, and your anonymous feedback will help us make TWiT even better. We thank you so much for your continued support. twit.tv/survey.
This is TWiL, This Week in Law with Denise, Howell, and Sarah Pearson. Episode 298, recorded April 3rd, 2015. Lawyers on Rails. This episode of This Week in Law is brought to you by Harry's. For folks who want a great shave experience for a fraction of what you're paying now, go to harrys.com. Get $5 off your first purchase by entering the code TWiL when you check out. And by FreshBooks, the easy-to-use invoicing software perfect for your law firm and designed to help small business owners save time billing and get paid faster. Join over 5 million users running their business with ease. Try it free at freshbooks.com/TWiL. And by Blue Apron. Blue Apron will send you all of the ingredients to cook fresh, delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 2 meals free by going to blueapron.com/TWiT. That's blueapron.com/TWiT. Hi, folks. Thanks so much for joining us for This Week in Law. I'm Denise Howell, and I'm here with an excellent panel of folks, a very entrepreneurial panel of folks with us this week. Also joining me is my co-host, Sarah Pearson. Hello, Sarah.
Hey, Denise. Happy to be here.
Great to see you again. How's everything going?
Good. Busy, but good.
Good.
Happy to be busy.
Yes, it's always good to be busy. And our guests are very, very busy too, as they have a startup, and you know that keeps you on your toes. Their company is called LawGives, and we have the 2 founders of LawGives with us, Pieter Gunst and Tony Lai. Hi, Pieter and Tony.
Hi.
Good to see you.
Really
Hi, Tony.
Hi there, Denise, Sarah. Really good to be on here.
Really great to have you. So, of course, it's always great to have business people on the show who are right at ground zero of what it's like to operate a technology business. Your business is right at ground zero of the intersection of technology and law, because you make a tool for lawyers and clients to connect with each other. Tell us a bit about LawGives and the history of the company, how you guys got together.
Thanks, Denise. Well, Peter and I, we met after having been lawyers for several years ourselves. So we come from a background of having sort of been in the belly of the beast, so to speak. But we met at Stanford, where we were encouraged by actually the approach of technology in its value to many industries. And I think one of the sort of adages around finding legal help is that sometimes it can be very costly and sometimes very confusing. And we were driven by a mission as to the way in which technology really opens up access, is democratizing opportunity in a whole range of areas. And being passionate about helping people find access to legal services, we wanted to deploy some of this technology that we were finding being used in all these other different industries and apply it really to an area we really cared about, which was getting access to legal help and access to justice for more people.
Yep, great causes, of course, both of those. And I probably know more than most how people struggle to find good legal counsel. I don't know if this happens to you too, Sarah, but just the fact that I have a bit of a footprint online and people can find me means that they get in touch and ask, whether I'd be the appropriate lawyer for them, or, who on earth can I contact is usually the case, because I don't know if people really realize that lawyers generally practice in a pretty narrow band of expertise. And so if you have a legal problem, it may be that a lawyer that you're familiar with and trust may not be able to handle that matter for you. So you need to get connected with just the right person. Pieter, do you think that a lot of people have legal problems out there that just never get addressed because of the difficulty of finding a lawyer and the expense of the legal process?
Oh, absolutely. I mean, we see this so often in our activities as a startup. I mean, I think, first of all, it's a very rewarding journey to come from the practice of law and then to be able to basically cross over into the technology side of things and basically on a structural level try to make it easier for clients to navigate this maze. And we sometimes think about the people who use our service in two big groups. On the one hand, we have clients that come to us and they're used to working with a lawyer, and they may actually know exactly what they need, and we're able to facilitate those connections to lawyers very effectively. But I would say that a large majority of clients comes to us and actually is unsure how to qualify their issue, and we support that through the software we build. And they certainly don't know how much they're going to pay. I mean, we're dealing with an industry that provides, yes, complex services, but at the same time, there's a complete lack of transparency when it comes to pricing. We're still in the age of the 6-minute billing increment and the hourly rate, although that's slowly shifting. And actually, market data shows us that, and sometimes it's hard to find this, but there's estimates that say that there's a $45 billion latent market on the consumer side, not businesses, where if price points would go down or if workflows became increasingly transparent, actually those clients would take the step of engaging counsel where today they do not. And the team, I think, there is, I mean, lawyers are often afraid of technology, but they see that things are changing, and you have to move if you want to stay relevant. But at the same time, we don't really believe that this is necessarily going to lead to the pie shrinking, because I think if we make the system more transparent, more easy to engage with, actually what is more likely to happen is that more clients are going to take the step more proactively of engaging with a lawyer. But yes, market data does show today that definitely a lot of clients are not taking the step of engaging counsel because the process isn't exactly transparent. And we also anecdotally see this every day, and we think that through initiatives such as ours, we can make a meaningful difference in that.
Okay, well, let's get a little bit more in detail and talk about the technology underlying your business and other technologies and technological issues relating to the legal profession, which relates to automating things and the Internet of Things. It's a new graphic. Yay. Hope you guys like our new robot graphic. Thank you again, Sando, our intern, for adding these fun little additions to the show. All right. So I saw a tweet from the Codex folks at Stanford. I'm sure you guys have been involved with them. You've probably not just attended, but probably spoken at Codex before, correct?
That's right. Both Pieter and myself are indebted to Codex actually for a lot of support. We're currently entrepreneurial fellows there, which is essentially a part of helping set up a community of entrepreneurs around this center at Stanford, which brings together some of the brightest minds from the law school, along with professors and graduate students at the computer science department at Stanford. And it's a really important part of actually what that sort of interdisciplinary environment can provide, which is to give the opportunity for people to come together and share knowledge. And I think there's no better area, sort of more pressing area, than to have knowledge shared between people who are at the forefront of technology, engineers, people who are developing these sort of predictive analytic frameworks, connection platforms, with the lawyers who are out there on the front lines as well. So that's really what Codex has been about for us, and we're proud to be a part of it.
Yeah, it's a really neat organization. And Pieter, I was reading in your bio that you actually have taught legal informatics courses at Stanford where you're teaching lawyers to code.
Well, actually, so Tony and myself, together with Ron Dolan, Ron taught it, and we basically helped prepare, and we're the TAs for it, the first legal informatics class given at Stanford. It's now a couple of years ago. But also, and when we're going to talk a bit about the technology underpinning what we are building, one of the things that we really realized very early, that it's all nice to have big ideas coming from a legal background, but to execute them, you'll have to build an interdisciplinary team of engineers and designers. And when we did very early, this 4 years ago, when the seeds for this project were planted, we saw that we were discussing technical requirements, we were discussing ways to tackle the problems that our customers are encountering. And it was very hard to communicate with an engineering team around, okay, what does it take to get to here? So at some point, I sent an email to Stanford Law School saying, hey, everyone, so I have a need to learn how to program, or to at least understand the technical sides of legal informatics much more deeply. So I'm going to start doing this thing every Wednesday night. And if you're interested in joining, you should come. And by the way, if you choose not to join, you may not have a job in 10 years. So you better do. And that first session was attended by 75 people. And now, Stanford Law School is not a big law school at all. And this has been running for 4 years now. It's gone through different iterations, basically working on a curriculum that allows people to drop in and step out if they have other courses and related obligations. But yeah, what they learn is not rocket science. It's like basic HTML, basic JavaScript, basic CSS, and then we go into Rails, which is a web application framework that allows you to build something really tangible. And we do that over the course of 3 quarters. And basically, I'm taking students who have never done this, and at the end of it, they can be at home, they can have an idea, and they can make it tangible. And it's called Code is Law because, as lawyers, we are already creatives. We write words. Code is not much different. The difference is, though, that it crashes immediately if you get it wrong. With contracts, it can take a long while. So I find that the skill translates really well. Plus, it's just super rewarding in this world of where the industry is now being touched by technology in a really meaningful way, to be armed with the jargon if you're going to talk with engineers, like in your law practice or in your other activities, and the ability to build an MVP, to build a prototype if you have an idea, to communicate that to others. So yeah, I mean, it's been a great success. It's one of a couple of activities that Tony and I do to support this field, rather than just our core like law gives activities. And it's been great. We hope to be able to be doing this for the decade to come.
Well, I'm so impressed with the tools that you're actually working with in teaching yourself and the folks at Stanford that you're working with. I kind of assumed that with a legal audience, you were probably starting out with scratch.
It is starting from scratch to a large extent, although, I mean, some of the pupils who have attended the course have gone way beyond my abilities, going into like lower level languages like C. And I think, I mean, it changed their career. And yeah, it's just incredibly rewarding.
Right.
And I think important for lawyers to be aware of this. Like, at the very least, you step out knowing some jargon, which I think is crucial.
Mm-hmm. Yes, definitely important to know the lingo. And also, I agree with you that it's important to actually understand how some of these things work. And I'm not the only person who thinks that. The Codex people threw out a tweet not too long ago wondering about the legal standard of care, basically, and when it comes to technology. how competent do you need to be in technological tools to be able to competently represent your clients. Their tweet related to predictive analytics and whether lawyers who don't leverage predictive analytics would be guilty of malpractice. First of all, Tony, why don't you tell us what you think they mean by predictive analytics and what your answer to that question is?
So by predictive analytics, we're talking about projects such as Lex Machina, which is one of the earlier Codex projects, which came out, again, first as a law school project headed up by Mark Lemley, the IP professor at Stanford, but was spun out as a business, basically gathering data about different lawsuits, settlements related to the IP field. And this was essentially intelligence that would enable a lawyer to do their job much more effectively and much, as well as more efficiently. And I think it's perhaps the first about being more effective, which is the main driver around why I would say in the future, yes, this could be an issue around malpractice. If you are not using the tools that you need to be as effective as possible to serve your client's best interest, then that is a key part of it. But the second part is also interesting because I think this notion of efficiency and actually saving on costs is also incredibly important as well. And whilst there is some argument for saying you should do everything it takes and spend as much money and time as it needs to actually win for your client. In many situations, I think your client's best interests are probably not served by you running up a huge bill for them, even if it does end up with them winning. And I think part of the debate going forwards over the next few years, in particular as technology tools come to help lawyers potentially lower their costs, is what duty does a lawyer have to not just win for the client, but also maintain reasonable and affordable costs, not to blow through the roof in a sense.
I think we'll put our first MCLE password into the show, passphrase, because we do this a couple of times during the show for people who are listening and want to go to their oversight board if they're a lawyer or another business professional who needs to do continuing education. And get credit for watching the show. So our first passphrase is techie lawyers. And if you need more information about claiming credit for the show, head on over to our wiki at wiki.twit.tv. Find the This Week in Law page there. And we've got a whole page about the various U.S. jurisdictions for lawyers who might be interested in claiming credit for listening to the show. Let's stick with this topic. I'm interested, Sarah, in what you think about the whole notion of a professional minimum level of technical competence.
I think it's an interesting question. I mean, I think we certainly have a long, long ways to go before anything as specific as predictive analytics would be a part of that. Just partly just because people don't have access to those analytics. That's one big issue. And but yeah, just the question of what level of technological proficiency people need to have, I think, is a really interesting question. I was really surprised to see that article in the Delicious or in the rundown saying that 14 states, well, once Massachusetts goes into effect this summer, have this obligation for lawyers to keep abreast of technology. That was news to me. I thought that was really interesting. So it's interesting to hear that it's already a part of it. Yeah.
That flows from a change the American Bar Association made to its model rules of professional conduct. And these are rules that are put out as sort of advisory rules that the states can adopt. And 14 states will have adopted some version of that particular change. That means that lawyers, in addition to doing their ongoing training in substantive legal matters, are going to need to maintain some level of technical proficiency. I have the feeling the bar is going to be set pretty low on that, being able to access email, being able to do a competent search or two is probably all that people are going to be held to. But certainly the whole panoply of tools that relate to the legal profession go well beyond that. So it'll be interesting to see how that evolves. Pieter, what do you think that the minimum standard would be?
I mean, it's such a great conversation. I'm looking at the TWiL stream, and people are jokingly saying, "Well, document management. Huh? That's here's a technological standard that many lawyers are still aspiring to." I mean, another interesting interaction. I'm on this email list of Canadian lawyers, and for the past 3 months, I've been getting about 2 emails a day in this long-running discussion about whether digital signatures should be valid for certain transactions. We are really at the beginning of the implementation of more complex technologies in the legal workflow. If we look at email is inherently insecure. We're starting to see new initiatives that encrypt the content of that email end-to-end, and that go much, much more towards really protecting attorney-client privilege in these interactions. No lawyer does that today. It's incredibly problematic from a user experience perspective today to communicate with your clients like that. But if we think about it, and if we do see the services that a lawyer provides as something different, as something that needs an increased standard of care, then I think we as the legal profession need to think about how do we move faster in this. Because right now, to be seeing discussions about electronic signatures, where, 6-7 years ago, when I was practicing at DLA Piper, that was a fully fledged legal framework, right? So certainly in Europe, the rules tend to run ahead on the practice. But I think in these kind of technologies, but then also, I think more importantly and more realistically in terms of adoption in technologies that improve efficiency for lawyers, like document automation, I do think that clients should expect that the standards to which lawyers hold themselves are fairly high. That being said, I think that for a large number of these services, like even if regulators don't step in, the market will dictate their usage. Because if you as a lawyer are able to provide your services more efficiently because you're a patent lawyer and you use Lex Machina, or you do research and you use Ravel Law to do research, or you are able to automate large parts of your transactions, like law firms like Cooley and DLA Piper are making great headway in. I think the market might actually take care of the standards of care for a large extent. I don't think that's going to be true for encryption necessarily. There, the bar may want to step in, but I'm pretty hopeful about the evolution we'll see in the next couple of years, regardless of regulatory obligation.
What do you think about the whole access to justice issue you touched on earlier regarding your service and putting people together with the right lawyer? Technology is, on the one hand, sort of playing field leveling, but on the other hand, can be really expensive if you're getting into things that are very sophisticated and powerful. If we're going to talk about lawyers having a minimum standard of technological proficiency, is that going to have an impact on, say, legal pricing as they attempt to ramp up to be able to compete in that arena?
I mean, this is an interesting question because this is where Tony and myself come from. I mean, as attorneys, we did get to see clients who just couldn't afford the services of the big firm we worked for, even though they could have used them. And it's where we started. It's reflected in the name law gives. What we've seen is an increasing willingness for attorneys to provide services on a sliding scale basis. That happens in our platform. What we've also seen is that the price transparency that we aim to bring for a wide series of services is really helpful because it sets expectations, it sets a baseline. But I think, one of the great challenges that we get to play with every day, and it's one of the things we're passionate about, is that this does require stakeholder coordination. This is a field where legal aid organizations are already doing great work, and we see ourselves as a tool, as infrastructure to help facilitate their work. I mean, we are very, very keen on building a product that makes things accessible. And I'll give one example because it hooks into something we were talking about earlier, predictive analysis. Go to many online websites that help you find a lawyer and put in your issue, and they will ask you, well, tell me what practice area this is in, because this is something that they need for matching. What we did is we built a piece of technology basically based on historical data that will do an analysis of the words that a client types when describing their own legal issue. And we use a machine learning algorithm that will classify this into practice areas automatically. And that's important for two reasons. Now, the first one is that it takes away the burden on the client side, who is often not sophisticated, to have to know what this is about, right? And that's lowering the barrier. And that is especially important with audiences that are on the lower end of the market, frankly, and often need that help the most. The second reason why it's important is because it allows us to scale. If you're doing things online in this field, then yes, it's important to do it first at a micro scale and to understand all the interactions of this very, very complex industry and interaction. On the other hand, you want to make this tool available to a huge audience. And because we can determine automatically what a certain issue is about, we can also very scalably and more importantly, immediately notify lawyers who might be a good fit for an issue. And all these things work barrier lowering, in particular for the kind of audiences that you refer to. But I think in terms of access and prices, yeah, I mean, there we see a trend in the market where lawyers are willing or more willing to provide services on a sliding scale basis. I think, frankly, it's also a matter of the motivations and reasons why many of us went to law school in the first place. It's because they want to help people. It's just that once you get out of law school with your huge student debt at your big firm, it gets pushed to the background. And we do hope that technologies such as ours will not only democratize access for clients, but also the ability for lawyers to work on things they're passionate about.
How do you handle geographic issues? That's one thing I've wondered about in situations like this, like, where the client is, where the lawyer is, and whether or not they can practice law in that jurisdiction. How do you match geographically as well, or?
It's taken into account into the matching process, as well as other factors like responsiveness of a lawyer, load balancing, things like that. We verify the license of every attorney on the platform, and we also have a continuous monitoring process where attorneys basically get feedback from clients that they interact with, and all that together forms something that's scalable and that's also has a sort of internal enforcement mechanism for quality control. I mean, frankly, a lot of this is also being done in other industries. Like if we look at organizations like Uber and Lyft or Airbnb, many of these trust mechanics are basically what it takes today to build a marketplace that not only has liquidity, but also has the necessary trust embedded into it to function well. So, and in the legal services area, I would say it's more important than in most other industries. It really does require an increased level of trust. And yeah, the algorithm is there and matches and will take into account location. But there's so many other little details that go into making that experience one that works.
Sure. Yeah, I just wondered because, and this may be a misunderstanding, but I thought that at least some states consider that you are practicing law in the state where the client is. And so if you were matching people, on the other side of the lawyers on the other side of the country, I just wondered how those issues kind of played out.
Well, we see in practice that lawyers still have a client still have a preference to work with an attorney that is geographically close to them, even though they are less concerned about meeting that attorney in person. Mm. So basically, if you think about it as going down a tree, and starting with, okay, who might be the best match, and then going down further, like as long as there are attorneys in the network in that area, they will be able to see that request. And actually, one of the parameters of the platform, very important, is that attorneys who are in our network can see any requests. Where, I mean, all of this is structured in very deliberate ways because of the ethical framework in which we operate, and we're very keen on finding solutions for, I mean, I guess, what are difficult problems and making them work on a scalable basis, which is, I think, a huge challenge, because you can structure something for California alone, and you may be able to do it in different ways that are, from a financial and a user experience perspective, may be more interesting to the client. But that doesn't help you a lot if that means that you can't do it in Florida or New York. So these are things that we need to take into account in what is, in the end, a fractured landscape of regulation.
All right, I think we're going to take a little break and thank our first sponsor for this episode of This Week in Law, and that is Harry's. Harry's, of course, is fixing a problem that most of us have. Sometimes you pay too much for lawyers, but you're probably almost all the time paying too much for razors and razor blades. Let's admit, shaving's not that fun. It's sort of one of those mundane things that people need to take care of in just a daily routine way. You can cut and scrape yourself with a dull blade, which is definitely not that pleasant. Razors are just expensive. They can run to $4 a blade. A guy who shaves every day spends hundreds of dollars a year just on razors. Those Gillette Fusion ones, for example, are quite pricey. And when we go to the store to buy them, sometimes we have to deal with those pesky locked up plexiglass cabinets. It's if you look on the web for humor about those things, it's quite high. People having to bash them open and get at their razor blades. It's such a pain that it's actually the butt of a great many jokes. There's a company that's fixing all that for us, though. It's called Harry's, and it gives you high-quality razors at about half the price of those big brand blades. And I got to say, I think they're better quality. They make their razors in their own factory in Germany. They engineer them for sharpness and high performance. They ship them for free to your doorstep. And because they make and ship their own blades, Harry's is a more efficient company, which means they can give you factory direct pricing. Harry's guarantees your satisfaction. In each kit, you're going to get a razor with a handle that looks and feels great, 3 razor blades, and foaming shave gel. The starter Truman set is an amazing deal. You get all of this for just $15. I've been using Harry's for a while. My husband uses it as well. We both shave in different ways, and we both love the product. It gives a clean, close, and comfortable shave. The look and feel is really nice, very clean and crisp, and really holds up over time. It's not a cheap, disposable kind of thing. Your handle's going to last for quite some time. The price, Harry's costs half as much as the razors at the store, and they also have a new aftershave moisturizer that protects and hydrates the skin. So you have to check it out. Go to harrys.com. You'll get $5 off your first purchase with the code TWiL, TWiL. That's harrys.com, and enter the code TWiL at checkout. Thank you so much, Harrys, for your support of This Week in Law. All right, well, before we leave this topic of legal technology and legal informatics, I wanted to just chime in and say that, I think our conversation has been indicating that we're seeing a geekification of the legal profession that plays out, I think, at all levels. Last year, people, I think, were sort of stunned to see the degree of savviness that the Supreme Court justices in the United States evinced when they decided the Riley case and recognized that things on people's cell phones were entitled to high privacy protection. The Supreme Court has been becoming more geeky over time, I think. I've been reading a great book called How Not to Be Wrong. Great read if you're interested in statistics and data and the believability of statistics and data. It's by Jordan Ellenberg. Definitely check it out. But he has an anecdote in that book that went right by me in 2010 when it happened, but it was an exchange with justices of the Supreme Court in the case Briscoe versus Virginia, where a lawyer making an argument in front of the court tossed out the word orthogonal. And it brought the whole court to a standstill when Justice Roberts, who didn't understand the word, had to stop him and have it defined. And then Justice Scalia jumped in and just really loved it so much that he said, ooh, orthogonal. So mathematical principles working their way into daily discourse and even discourse in front of the Supreme Court. So I'm not too surprised that lawyers are slowly but surely coming around to the century in which we dwell. Let's move on to another topic that hit the news right after we finished our show last week, and that was the Ellen Pao verdict. And since we've got a couple of Silicon Valley startup guys on the show, I thought it might be fun to hash through that and see where we think things stand. So this is one of those other categories of things that we don't often or always talk about on the show, but I think is definitely worth the discussion. That's where I really feel like I'm Conan O'Brien hitting the big button when we play the other bumper. All right, so Ellen Pao had her jury come back as we concluded the show basically last week, not in her favor in her discrimination case against Kleiner Perkins. And the jury heard a bunch of evidence about a very gender-charged environment at Kleiner Perkins. A lot of things that Ms. Pao went through that were unpleasant in many aspects and definitely seemed to be targeted at the fact that she was a woman, various advantages or ways that she was treated at work. But where the jury really struggled, it was tying that to her lack of advancement at the firm. And that's a problem in a lot of these cases, that it may be possible to show that there's a less than great work environment going on, but unless you can also show that that's why you did not get that promotion or get put ahead at the firm, you're not going to win your employment discrimination case. So this seems to be what happened to Ms. Pao. And it's just, we have talked on the show before about the environment, the sort of situation in Silicon Valley where there could be gender-related bias or disadvantage going on. And I'm curious to get your guys' take on that as two folks who came out of, you guys were involved in incubator at Stanford for your business and have been through the venture process, correct?
Sorry, just unmuted myself. That's correct. We went through an accelerator called StartX, which is a nonprofit and has a focus less around sort of market potential per se, being a nonprofit and not being a sort of a profit-driven motive with investors behind, but it's more about education around entrepreneurship, supporting founders in doing that. And I think one of the recognitions around supporting entrepreneurs more generally was the fact that mentorship and role models plays a huge part in supporting that entrepreneurial progress. There's a very, very structured mentorship program that has been set up at StartX, which involves both having a sort of a lead mentor who's almost a personal coach, as it were, as well as a board of advisors who act more as a sort of proto board of directors. And I say that in the context of this discussion because I think one of the biggest issues around diversity and in all fields, but women, minorities, but getting that access is having good mentors and role models to be able to look up to and able to guide you through what can otherwise be a very intimidating environment if you're not one of the sort of like the majority. And so there was certainly a sort of intentionality that was embedded within StartX that some of the women entrepreneurs coming through would be paired up with people that they who have been successful, and there's a specific program now being put in place by one of our new staff members that's specifically focusing around supporting women and minorities in getting that sort of acceleration as part of their entrepreneurial development. So I guess I mean, looking at one of the articles that that are listed on the list that you shared, the Vox article in particular, I think it speaks to this point around like the difference between a legal standard, which is very hard to prove, along those lines, but also the fact that there's an inherent value to actually getting ahead of the legal standard, and that comes in both ways. Both on the negative side, when you have a lot of bad press around what's coming out for Kleiner Perkins, but also on the positive side around how you can actually get ahead of that and recognize that you want to create a culture of diversity, because that's actually going to be really good for your startup and your business going forwards.
Right, and I think it's probably less of a problem for folks like yourself who are younger and probably have a different set of values. One of the articles that we have in our rundown for today, and folks can access all of these at delicious.com/thisweekinlaw/298, is talking about sort of venture firms in particular having a culture of needing a really small group of tightly knit, often fellows, who are used to working together, know each other very well, can get things done. And I think for folks of a younger generation, I trust and hope for folks of a younger generation that having women and minorities included in that tightly knit group of folks who know each other very well won't be such a struggle. Pieter, do you see that playing out? Do you have hope about the situation and tech businesses in general?
Well, I absolutely, and I think, the awareness of this issue and the fact that it is being talked about more over the last couple of years has been pretty apparent to me. So I think that goes a long way into changing hearts and minds and creating that consciousness. But I think, as Tony said, the way we think about this is, when you're a startup, what you are is you're a temporary organization that's looking to become a company that finds product market fit and can scale up. Now, the question is, how do you optimize your success in doing that? And what we've seen is, and this is true about Daniel, who is our CTO and who thinks very differently than we do. It's true about Hannah, who's sitting next to me here, who brings the perspective of someone who's like finishing up law school and really is part of that generation that grew up with the internet just a bit more than we did. And what we see is when we're tackling problems, like Tony and I have a particular way of thinking about things. It's complementary, but it's still different than the rest of your team members. And to the extent that you are successful in bringing in diversity, and that is women, that is minorities, you will be able to iterate on that process of getting out of startup mode and becoming a scalable company faster. So just thinking about the positive side of this, what I hope is that companies that think like us are going to win in the marketplace. And then this problem solves itself. But I think, yes, it is a generational shift. Like looking at my mother, who worked in like a large corporation, and like the experience she went through, like I think, and various studies show that like women are at a disadvantage, and it's time for that to change.
Yeah, I think when I was a child, it was in the 70s basically. And I think we all thought then, yeah, things are pretty bad now, but by the time you children are grown up, it's going to have all worked itself out. And by the time I was in the workforce, I don't think that it had worked itself out as well as we had hoped that it would. I don't think Ellen Pao thinks that today, and she's far younger than I am. Sarah, what's your take on this?
To me, I think I've been really lucky in my career to avoid situations like the one it sounds like Ellen Pao was in, where there was just this really blatant sexism. Even though she couldn't prove that was the cause of why she didn't get promoted, it sounded like there was a lot of evidence that there was sexism, pretty obvious sexism. And I have to say I've been really lucky. I don't think I've ever really experienced that in my career. What I have seen, especially when I started at a big Wall Street law firm, when I started my legal career, and there just weren't female role models. Not that there weren't. There were a few, but there were just a handful. And so that mentorship, that ability for mentorship was really something. There were maybe 3 mentor partners that you could get, and then we had 50 at least 50 associates, half of which were women, all vying for those same mentors. And that's tough. That makes it a tough situation. It's not sexism, it's just the reality, but it affects the whether or not women stay, I think.
So Craig Newmark got taken in, so he says, by his team, who tried to play a joke on him, and they told him that a study had reported that 0% of women-led startups were funded, and that number was not quite right. The situation is dire enough, though, that he bit on 0% and went, really? Is that really true? It wasn't really true, but the real stats weren't much better. Only 7% of investment money was going to women-led startups per this study, which is still a pretty low number as a group that's starting out and getting funding yourselves, guys. What do you think is the reason for that really low number?
I mean, I go back to that point that Sarah raises, which is the lack of role models and the lack of people who are really sort of looking out to actually make that change in an intentional manner. I mean, happily, there are groups that are out there that are looking to, really push on that and are addressing that as their core issue. There's a group that I was put in touch with called Golden Seeds. A friend of ours, Rick Hess, knows one of the founders very well, and they're specifically set up to focus on women leaders. And I think this is a great thing, because we're looking at having a very sort of concentrated focus around establishing those role models, both in the venture and investment community, as well as supporting founders coming through. I mean, we've actually also been very intentional about wanting to balance out the fact that myself, Peter, and Daniel we're all men. So we're bringing in a very senior leader in the legal world. Van Dang is her name. She was a deputy general counsel at Cisco, to join our leadership team as well. And partly that's because she is an amazing person who understands legal technology down to the ground, especially from an in-house perspective, but partly because she is a very strong and vocal supporter of diversity, and being a strong female executive, will hopefully bring that level of intentional culture and diversity to our business as we grow as well.
Yeah, it does seem like in the aftermath of the Pao case, this issue is getting a lot of positive attention and a lot of productive attention. And Craig Newmark, for example, is partnering with Women Who Tech to launch the first ever Women's Startup Challenge. A bunch more really wonderful resources and programs mentioned in his post at Craig Connects, if you guys want to check that out during or after our discussion here. I have my personal take on when I read his post and saw the results of this study on 7% of investor money going to women-led startups, is that maybe women are so smart that they don't want to give away controlling interests or trade away controlling interests in their startups for the venture money. But I fear that that's an optimistic and somewhat tongue-in-cheek assessment of what's going on. Sarah, any final thoughts?
No, I don't think so. I don't. This is a huge issue, one that there are definitely no easy answers to. I haven't followed Pao's case very closely, but yeah, I don't really have any. Got nothing else.
All right, so let's entertain ourselves by moving over to the sector of entertainment, law, music, etc. So speaking of April Fool's jokes, I have to share with you the one that I bit on and was halfway through Bob Lefsetz's article on April Fool's morning before I realized, oh my God, no, Apple didn't buy Spotify. And this is all just a very cleverly written piece on how that might or should happen. Bob Lefsetz did a really lengthy and detailed and completely straight-faced and deadpan post about Apple buying Spotify for $10 billion and went through all the reasons why this was such a great thing and how smart they are. And Apple's now going to own streaming. And the whole thing with Taylor Swift and Spotify was just a ruse. And she's actually been working with the Apple folks all along and now stands to benefit from the acquisition. And it was about at the Taylor Swift point that I realized I was being had. But great post, and really quite an interesting thought experiment about what would happen if Apple were to buy Spotify. Who knows? I guess there were some rumors. I didn't even realize that until I read Bob's post and tried to figure out if this could possibly be for real, that there were some rumors early in the week about Spotify being sought after for quite a lot of money, as obviously it would have to be if it were to be bought. And so, Apple's certainly one of the candidates who could do that. But apparently this was just a thought experiment, and it was a good one. So I encourage you to check it out. But in the world of streaming music, not a joke, is TWiL from Jay-Z, which not only involves Jay-Z, but other huge artists as co-owners. And their spiel is to be the artist-friendly streaming service, to pay artists more than they get from outlets like Spotify or Pandora. And I just, I guess my reaction to this is not to say, oh, it's never going to work, but it's a wait and see. And certainly it's a niche that hasn't been explored yet and may wind up gaining traction because clearly artists do want to be paid more as we move more into a streaming environment. So, Sarah, I'm wondering what your take on this is.
Yeah, I guess I have the same take, kind of a wait and see. I mean, so it's an interesting model. Just to talk a little bit about the specifics, the regular tier is $10 a month, or just $9.99. And then they have the hi-fi tier, which is $20 a month, and it's for these really high fidelity audio tracks. And me, I am not a music person that would ever be in the market for this, so maybe I'm just, biased, but I'm kind of skeptical that there's a huge market there, but that's what they're, I guess, banking on, because it's at that tier at which they will pay the higher royalty rates to artists. So they're banking on getting enough subscriptions for that hi-fi tier that it translates into more money for the artists that get streamed. So it's an interesting model, very different from what Spotify does, which is use their free product to lure eyeballs for advertisers, and then they get enough people to pay for the premium service. That between the advertising and then the premium payers, those things subsidize the free. But TWiL is nothing is free. I think you can get maybe 1 month free, but after that, everything comes from subscription money. So, and I don't actually know if they're going to have an advertising element or not. I would guess so, but I don't know the answer to that. But it's obviously a very different model. So yeah, I'm skeptical, but we'll just wait and see. Maybe it'll be a huge success. Jay-Z is obviously a brilliant entrepreneur. So.
Right, and the marketing around the launch reflects all that, et cetera. I do think that if they are going to incorporate ads, that's going to be a tough sell. If you're paying $10 a month and getting ads because you're at the lower tier, that's yeah. But who knows? You're right. Maybe that is how they'll subsidize the lower tier and still get the artists the money they want. Again, I'm willing to sort of leave the jury out on this one and see how it goes and whether it offers, enough of a catalog and a great enough experience that it's going to actually be able to compete with Spotify, which I would say is that's the big elephant that it would want to bring down. Tony, what do you think? How do you listen to music?
Generally on a sort of pretty ad hoc basis with streaming services like Spotify, like Pandora. Use one that a friend of ours, Asa Raskin, developed called Songza as well. And it's, the ways that I've consumed music have just been constantly changing as the new services come out. Like to stay on the edge of what is new. But at the same time, I think, this is a really interesting area. Obviously, another example of an industry completely changed by technology and the internet. New business models have been a key part of the constant evolution, going from selling records and selling CDs and then, MP3s and now streaming. And we actually looked at this in one of the law school classes that Peter and I were both a part of, taught by one of the, taught from a couple of perspectives. One, from the perspective of the law, but also from the perspective of some of the engineers and business people coming in from the graduate schools departments. And again, thinking about this from not just the legal perspective and what the state of the art of the law, copyright law, which is, pretty complicated. It's one of the more complicated areas when dealing with the different rights involved with both the producers and the distributors and the artists as well. I mean, it's a big hodgepodge of law. But then from a business perspective as well, how are music artists going to really be making money, when you sort of have this celestial jukebox, as our professor Paul Goldstein sort of first referred to it. I think the jury is still out. I think there are a lot of different business models out there for artists to potentially capitalize upon, not just around streaming, but also around how their music is used in movies, how their music can be remixed into other new creations, and whether there is in a sense, a market for how artists can, both have their rights, but also license those rights out for all the different ways in which people want to consume music going forwards. Because frankly, I don't think it's always going to be just a listening experience anymore. As with everything, it's going to be remixed. It's going to be more interactive. Music's going to sort of start filtering into different areas of different fabrics of our life as well. So I think as with everything, change is scary, but it's going to lead to new and better things, hopefully.
So I have a hard time looking at a new service like TWiL and not seeing it as a direct descendant of what went on legally with Napster. Napster begat the iTunes Store, which is now struggling to keep up with the streaming sites like Spotify, and Spotify now struggling with artists, a la Taylor Swift, Pandora as well, struggling with artists. So this would be the answer to that. Do you think, Peter, that it has a chance?
I mean, it's fantastic that you asked this question, because I'm thinking about a story. We had a number of super fun interactions with a man also called Pieter, who was the early CTO at Napster. And back in the days on California Street, which is one of the main arcs next to University Street in Palo Alto, this was where Napster's office was. And in the early days, they had a bunch of groupies standing outside of the office, basically supporting them and trying to touch the various people involved. And it's sad to see that legal technology hasn't moved there yet. We often don't stir up that level of enthusiasm, although we try, and many people care deeply about this issue, as they should. But I think, services like these, we'll see what wins in the market. They're kind of late to the game. One aspect that I found very interesting, that also is parallel to the legal industry, where we always take our perspectives back to, is the fact that they put it out as this is something that is artist owned, right? We are leading this. It is us who put this out, rather than the big corporations who are not looking to maximize artist profits, but are looking to maximize their own. And the interesting parallel there is that we here, having spoken to tons of startup founders and helping them with their legals, are also seeing all these new and interesting models of corporations emerge. Because you are in a world today in 2015 where the sharing economy, underpinned by new technological means, is becoming a real thing. But it also means that the idea of what a corporation should do and what its purpose should be is changing. So you get things like the benefit corporation, or you get an increased emphasis on ownership, like the new equity crowdfunding rules that the SEC confirmed last week. It's super interesting to see artists think about, okay, how do we structure this organization in a way that benefits artists primarily. And I think the credibility of that narrative may be affected a bit by the fact that it's Jay-Z and not the guy who's playing guitar on the corner of Webster and Oak here is putting this out. But it lets us think, like, yes, how is this being structured, and is this a better way for this to work? And I mean, it's obviously something artists have done for a very long time. You have these royalty collecting societies that exist, and they are in the end, their purpose is to be artist driven. So this is kind of another iteration on that. So yeah, I do hope they're successful. I think the more business models and iterations we see of these kinds of services, the faster we'll get to something that matches consumers' needs, but also optimizes for the benefit of the artist, which I think is where we should be looking.
Yeah, there's an interesting comment from Reverb Mike in our IRC about another competitor to TWiL that we haven't talked about here today, and that's YouTube. People don't necessarily think of YouTube as their music service, or maybe people my generation don't, but people my kids' generation do for sure. And that's a whole different way of experiencing the music. There is absolutely free. They have their own copyright regime in place and partnerships with labels and other things that make it work. But it is orthogonal to the streaming services, perhaps, but it is definitely there. Go ahead. I want to get your reactions to that.
I'm not sure whether it's orthogonal. I mean, so Tony described the different ways in which he consumes music, and I share some of those. But my primary way of consuming music is YouTube, because it's the ease of access, right? I can Google the title of a song, and the video will come up first, and I'll have free access. I primarily listen to radio in the car. So when I'm listening music at a computer, that's where I'll go. So I think, yeah, I mean, I definitely, if that wasn't an alternative, I'd be paying the premium fee for a Spotify, which I'm not.
Right. And YouTube, recognizing that, has definitely taken steps recently, in recent months, to beef up its music aspect of its service.
One thing to bear in mind.
Oh, go ahead.
Sorry, just very quickly on YouTube, and I don't know the detail around this, but I've certainly had some feedback from some of my artist friends, and I think they'd classify themselves more as indie artists rather than successful artists at the moment. But YouTube recently came out with some very interesting licensing requirements, specifically targeted at a lot of artists, up-and-coming artists, who are using YouTube to sort of help to get an audience. And these were really restrictive licensing requirements, where basically they were saying to these up-and-coming artists, you have to make all of your sort of catalog available through YouTube and nowhere else. So it's essentially saying this is, if you want to continue benefiting from YouTube as a distribution channel, then you have to give us an exclusive. Which again comes to the point around artist rights versus a corporation's rights, and where those sort of sometimes come into conflict. And I think where potentially TWiL, certainly with their approach and their signaling, are trying to be something very different. Now, one of the articles that you shared, I think it may have been the Vox article, also points out the slight sort of, I guess, difference between the messaging and the actual sort of carrying out of it, in the sense that the artists who are the founders and who are going to get the vast majority of sort of ownership are, some might say, artists who are past their prime, and sort of new and up-and-coming artists who are going to try and, build out the rest of the platform are not necessarily going to get the same level of ownership. But I think still it's very different from where a corporation is essentially imposing its will on you and sort of take it or leave it. And so, yeah, just wanted to, I guess, throw that in as a sort of rider to the fact that, yes, YouTube is free, it's a great streaming service, but they've also got their own business interests as well, which may play into how this all plays out.
Yes, definitely. Let's make Apple buys Spotify our second MCLE passphrase for the show. And let's talk about Robin Williams and his right of publicity after death. Sarah, can you bring us up to speed on that?
Yeah, this was a really interesting story. Apparently, Robin Williams bequeathed rights to his name, likeness, photograph and signature to a charitable foundation that was set up by his lawyers before he died. They are not allowed to exploit any of those publicity rights for 25 years after his death. And I think there's also, a big tax piece there, that the idea of giving it to a charitable organization is to avoid some state tax liability, but I don't know enough about taxation law to know how exactly that works. And I've also one missing piece for me, and I don't know if you know this, Denise, is what the charitable purpose of the foundation is. I assume it can't just be to hold his publicity rights, but I don't know enough about what else they're doing. Maybe they're donating a lot of his money to charitable causes. I guess that would be an obvious one, but I just don't know for sure. But apparently this is a real
I don't know that either, and haven't looked at this too closely. The part of it that interested me is the whole notion that you could take rights of publicity, and number one, the notion that they survive a public figure's demise, and number two, the fact that you could lock them up through estate planning, or if you could do it through estate planning, then you could conceivably do it through contract as well. So you guys both have IP law backgrounds as well, and I'm wondering if you have any further thoughts about this, Pieter.
So many. The field of IP, I mean, whether we're talking copyright, patents, trademarks, there's some very, very old school restrictions being placed on what we can do with information that, in my personal opinion, are going to be really hard to scale in the internet age. I mean, it's beautiful if people can if they can stand on the shoulders of giants, if they can take what people before us have done and can create new things out of it, right? And frankly, I understand the need to, and strongly believe in the need to reward artists. I'm just sometimes wondering whether these very elaborate rules that certainly when you try to think about this in an international context, where like a Spotify has to go to Europe and needs to like figure out in each country whether they harmonize the EU rules correctly and then like figure out that minefield. I just don't know if that's how we want to do this. I think there's an argument to be made that like services that make it super easy to access this information, like a Spotify, that's just how the market should work, and they can distribute to royalties. That's something that could be done by contract. Are really a boon for innovation, and I think we're seeing the courts take a very critical look at this and basically moving towards decisions that say no, this isn't great. So I think this is a very exciting time for IP lawyers. I mean, when I started practicing law, I saw myself as a lawyer that was going to specialize in this whole mess created by the internet, which just aggravates these problems like to the nth degree. It's gonna be work for lawyers for decades to come. That's for sure.
That can't be a bad thing. If it looks like, Sarah, that they've taken into account the notion that the charitable trust, if it gets set aside as not having a sufficient charitable purpose, then the publicity rights are going to be distributed to other charitable organizations that are unassailable, Doctors Without Borders, AIDS, Make-A-Wish, that kind of thing, so that they actually could get divvied up. But I assume that the 25-year use restriction would still apply, even if those organizations wind up with the rights. Tony, do you have any thoughts about this?
I mean, just building on what Pieter said, I think, this really signals how lawyers being sort of on top of technology, not just from their practice purposes, but just in order to stay up to date in their own practice areas, how important that is. An area like estate planning, not necessarily considered like a top candidate for innovation, and yet the lawyers who crafted this were clearly very creative, and they were creative because they were on top of this notion of publicity rights in an age where your presence and your identity are all all over the internet, and there can be mediated through technology like holograms. When you have performances of dead artists up on stage, what does that mean then for a well-loved and respected actor like Robin Williams, who wants to have a modicum of control over how his image is used to promote things that he really believes in? And I think one of those interesting things then is that the notion of law is a creative field, especially where you have these sort of cross-practice area considerations. The lawyers who put this together had to consider privacy law, estate planning, trademarks, publicity rights, IP rights, contract law, and I think that's one of the exciting areas for lawyers coming through today is really that you can have this creative role in sort of bringing the law up to date with the actual real life situations that technology is bringing in.
All right. Well, I think now would be a good time to thank our second sponsor for this episode of the show, which is FreshBooks. FreshBooks is the cloud accounting software designed from the ground up for entrepreneurs, small businesses, and is perfect for attorneys. It's one of those technological tools you'll want to be proficient in, folks, if you want to be doing a good job for your clients. And FreshBooks does a really good job for you, too. It takes those sort of old-fashioned ways. Peter was talking about how, we're still wedded to billing by 0.6 of an hour, et cetera. And FreshBooks handles that real well, or it can handle however your billing practices works. We tend to bill by the hour in this profession, and we need to track that time somehow. Just, gazing at your watch and trying to ballpark things is not very effective. But if you can track time by setting a timer in the FreshBooks app on your phone and then stopping it when you're actually done with that work and moving on to something else, that captures that work for you right then and there and puts it in an invoice, which solves another problem that I think people with small businesses have an issue with, and that is, who wants to do the accounting? That's really not what you're in business to do. You might not have employed a person who does that for you, so it's on you to make sure that it's done. Well, FreshBooks makes it just so quick and easy. You're not sitting around at the end of the month going, gee, I really need to get the bills out, but it's such a huge onerous task. With FreshBooks, it's almost on autopilot. It's wonderful. There are things that you actually can put on autopilot if you are billing routine things every month that are going to come back over and over again. That's going to automatically go on the invoice for you. You can set that up. You're not going to have to use something like Word or Excel or Google Docs to create those invoices. When you use FreshBooks, it's a much more professional layout and format, and it just takes minutes to generate. You can avoid those awkward emails and phone calls to any late paying clients because you can just send an automated late payment reminder to help you get paid faster and stay worry-free. You can set up recurring profiles. You can spend much less time on paperwork. You can free up to 2 days per month to focus on the work or other things that you need to be paying attention to rather than your accounting and billing. You can also use FreshBooks to help you with your expenses. What you do when you have billable expense or tax-worthy expense, you just take a picture of it with your phone, and it gets captured. It'll go right on your statements. It'll go right in your reports that FreshBooks keeps for you. You can instantly access those financial reports so you can keep track of expenses. You're ready for tax time. It's going to integrate with the apps that you use for your business: Google Apps, PayPal, Stripe, MailChimp, Fundbox, Zen Payroll, and more. And if you ever need help, you'll talk to a real person every time, and support is free forever. So try FreshBooks right now for free with no obligation. You can start your 30-day free trial by going to freshbooks.com/TWiL. And don't forget to mention This Week in Law when they ask how you heard about us. That really helps us out, lets them know that our loyal listeners are loyal to our sponsors as well. Thank you so much, FreshBooks, for supporting this episode of This Week in Law. All right, I think we're ready to move on to a topic that touches on both the law and copyright. So we've been talking a bit on the show about lawyers becoming more technologically savvy. One of the things that still prevails and governs us all, especially in the litigation arena of practicing law, is something called the Bluebook. And the Bluebook is a uniform system of citation. It tells you how to refer to precedential cases when you're writing briefs and statutes and websites and everything else that you might be citing as authority for your legal argument. And the Bluebook is this, it's literally a blue book, a blue spiral-bound book that is about as old school as you can get. But things with the Bluebook are actually moving forward, as I learned from the Law Gives blog. Pieter, you want to tell us what's going on there?
Oh, yeah, absolutely. So this is a hugely interesting topic that's about way more than the Bluebook. But what's been happening is you have the Bluebook, which Harvard Law Review basically publishes. And it contains these standards around how we are supposed to cite legal sources. Now, the problem is that this body of knowledge, this body of rules is not open. It's being commercially distributed. And there's been an effort that's basically been spearheaded by people like Carl Malamud, who are asserting that these kind of standards, because that's really what they are and certainly have become, should not be restricted by copyright, going back to our previous topic, in this way. And I mean, Tony and myself, we tend to agree. Like, we think a lot about how do you structure data, how do you build frameworks for things like citation or other legal operations. And it's just a better way of working to make that more open and collaborative. I think the underlying trend, which we are very excited about, is that the cost of information, the cost of this kind of stuff is going to zero. The internet allows us to collaborate, to build upon these standards, and it's going to crucially change, amongst others, the legal industry, because we have these huge corporations that for a very long time, often through exclusive agreements, have had exclusive access to knowledge that we as the public are all supposed to know. Like, there's a saying that everyone's supposed to know the law. That's incredibly hard. If you need to pay for a Westlaw account, if you need to buy a Bluebook to get access to these frameworks, we frankly think that's not necessarily right. What we believe is that this kind of information should be distributed to the benefit of the public than to be built upon. Right? And if you think about the trends in the legal market and what's happened in the past, like 10 years with things like document automation, I mean, what we're seeing is that this kind of technology, whilst extremely useful, is becoming cheaper and cheaper to create. If I can teach a bunch of law students over the course of a year to build basic document automation systems, like, what does that mean for these companies? Is it so that the real value is in the layer of services provided on top of this, right? A law student writing a well-researched memo, a lawyer taking a standard document and customizing it to your specific needs. This is where we think that the value in the future economy is. And if we think about the layer of information that's going to underpin this, yeah, I mean, it's basically in our interest and in the interest of the public to have that be as open and freely available as possible. One interesting angle to think about, too, is what this means for the future of law firms, right? You're dealing with basically a legal network that has a brand, that has all this infrastructure that lawyers share, and it's incredibly useful. But one of those crucial pieces of infrastructure, and I know I spend a lot of my time in it, was the legal library, right? Like, that's an asset that a law firm has, but it's just going digital. And it's like initiatives like Ravel, like, are now making this kind of information more available. So what does that mean for the need of the shared infrastructure, and how does it affect how lawyers can work together and collaborate? Like, that's the bigger question that underpins like a pretty specific discussion like this one around the Bluebook here. And we just think that's incredibly exciting.
Yeah, another exciting aspect of this is if portions of the Bluebook go into the public domain, or a scaled down version of it does, as it seems may be happening, that there's, nice basis for some startups to jump in and do something with that data and automate some kind of tool. I'm for all I know, there are already things that will electronically Bluebook your brief for you now. I have never used such a thing, but if there is not such a thing, there would be a nice market for that, because picking up the spiral bound Bluebook and checking each of your citations with it, which is something that, I've been used to doing for years, is not the most efficient way to actually make sure that you've caught every citation and that they're accurate. As your Creative Commons representative here, Sarah, I'm wondering what you think of all this.
I'm just thinking how glad I am that I don't have to deal with the Bluebook anymore. Having bad nightmares of my litigation days.
Yes.
Also, I was just thinking anecdotally, hadn't really thought about it, but since I went to Creative Commons, I don't have access to Westlaw. Not only do I not use a Bluebook, but I don't have access to Westlaw or Lexis. And I do still do some case research, but it's so much easier to find stuff online now without using those paid services that I don't really end up missing it. I mean, there have been times where I thought, I have some ideas of ways I would tailor a Lexis search or something, but it's just kind of interesting to think that you can practice law, probably not if I were a litigator, it would be different, but you can practice law and have to do some research and be able to do it all completely using free services online, which I think is great.
So, Tony, maybe none of this matters at all, because according to Vint Cerf, we're not doing a good enough job of making sure that any of the things that we're saving digitally these days are going to be readable by future generations. So it really doesn't matter what our briefs look like or how we check the sites in them, because no one's going to be able to read them in the future anyway, right? What do you think about that, the digital dark age?
I think he, to some extent, has an interest in saying that, being at the company that organizes the world's information, and so there's to some extent maybe a little self-serving in sort of putting out that prophecy of doom. I mean, personally, I think that one of the biggest challenges we're going to face is not necessarily saving everything, but being able to filter everything. I think that's the bigger challenge in an age of where we do have orders of magnitude more capacity to save information. It's going to be what we decide to firstly save, but also filter into our sort of awareness. I mean, I think the biggest challenge is actually going to be information overload. And so the most useful tools are actually going to be around not just organizing the information, but how that gets translated into usable information, into knowledge, and ultimately into wisdom. And I think that's one of the reasons why lawyers who sort of perform that role as part of their profession, it's something that isn't going to be at the higher level, transferring that information and helping to filter that into knowledge and wisdom. How that isn't something that's going to be automated all too soon. And ultimately, that the usefulness of information is ultimately how it really applies to you in your day-to-day life. And so I think having certainly open access to information is important, but then open access to those tools that can really help you sort of filter that down and get what's important are going to be actually more important than just saving everything.
Yep, excellent point. All right, we're going to thank our final sponsor for this episode of This Week in Law, which is Blue Apron. Goodness knows we all love to eat, but it's hard to find a meal that doesn't compromise somewhere, whether it's on taste or quality of ingredients, complexity of flavors. You need it to be a good value. You want it to be quick to prepare. You want it to be healthy and delicious. And Blue Apron hits the ball out of the park on all those fronts. It's absolutely easy and delicious and fun. You're going to get fresh, ready-to-cook meals delivered right to your door. And for folks who've been watching the show for a while, as Blue Apron has been a sponsor, you know that often I will show pictures of the Blue Apron meals that I've made. I have to apologize that this week I don't have one to show. And the reason, though, is because Blue Apron is just so darn good. I made a particular dish that were, I think Victor's going to put it up for me so I can give you the exact title. There we go. That's what I made. They were these delicious, delicious burgers with a cheesy sauce and sweet potato fries on the side. and everything was just so scrumptious that we could not wait to take a picture of it before we dove into them. So I'm having to show you the Blue Apron, a very nice glossy photo of what we rapidly consumed. And I swear that these burgers were exactly the kind of thing that you would get in a burger specialty bistro. And yet we were able to make them at home. And they just came out stunningly great. And this is just one of the many hundreds of meals that you're going to get when you subscribe to Blue Apron. And they do a great job of going from, your basic burger with sweet potato fries on the side, but really nothing about Blue Apron is basic, because those fries are going to come drizzled with olive oil and thyme, and the flavors are just phenomenal. So, a burger kind of meal, or you're going to get something really exotic and from all over the world. They bring in flavors and items that you might not even be able to find at your local grocery store, but yet they come fresh and delicious right to your home. And they do so for less than $10 a meal. You're going to get fresh ingredients, perfectly proportioned, with step-by-step recipe instructions, beautifully printed pictures, as we're showing you here. So you know what you're trying to make, and you can do your best to make it look like those beautiful pictures. And the meals are healthy and easy and fun. They're great if you're not the primary cook in your household, or not, an academy-trained chef, because what you produce is going to make it feel both to you and the people who are eating like you are. It's a really great sensation. Perfect for date night, cooking with friends. Perfect for, if your primary chef is under the weather and you want to do something really nice for your family. Nevertheless, your whole family is going to eat well. It's fun to involve the kids too, because again, the proportions are all there for you. It's a great opportunity to show someone how to zest a lemon and give you a hand in the kitchen. Each meal is calorie balanced at 500 to 700 calories. So yummy that you'd never know that that's all you were eating. Cooking takes about half an hour. Sometimes a little bit more if there's some more chopping or prep involved, but usually not much more than that at all. Shipping is free. The menus are always new, and they won't send the same meal twice. They'll work around your schedule and your dietary preferences. And Blue Apron's experts source only the best seasonal ingredients for incredible meals like pan-seared chicken verjus or roasted Japanese sweet potatoes. You'll cook incredible meals and be blown away by the quality and the freshness. And guess what? You're going to get 2 of these meals to try on your own for free. That's right. Go to blueapron.com/twit. 2 meals for free just by going to blueapron.com/twit. Thank you so much, Blue Apron, for your support of This Week in Law. All right, let us move on to a privacy story. So this lawsuit has been pending for a while against Hulu about disclosures over subscribers' video viewing practices. And Hulu has beat this lawsuit. Sarah, can you tell us a bit more about what happened here?
Sure. So Hulu was sued for violating the Video Privacy Protection Act of 1988, actually, which is a statute that prevents videotape service providers from knowingly disclosing personally identifiable information. And the claim was that by adding the Facebook like button to Hulu and then passing that information about who liked what videos onto Facebook, that gave Facebook enough information to piece together some personally identifiable information. And the judge said that basically that this wasn't actually knowingly done because they were giving 2 different pieces of information that Facebook then had to make the connection in order to identify who it was. So there was the cookie info and then the video list were separate, I guess. And then the idea, this is really, if you can tell by my tone that I think this is a really weird outcome. I didn't read the full opinion, but just this idea that that Hulu wouldn't have known that Facebook was probably going to put those 2 things together seems like a really weird outcome to me. But that was the decision, and so it got dismissed on, I believe, summary judgment motion just this week, if I get the dates right.
All right. So that's one that would have been a big deal for Hulu to lose, but they did not. Pieter, what do you think about the outcome here?
I mean, by way of background, when I started my my legal career and then subsequently at Stanford, took a keen interest in liability of intermediaries. So there's a European directive. A directive is something that needs to be implemented by each European member state, called the e-commerce directive, that basically regulated the liability of intermediaries, initially ISPs, but also services like Hulu, Facebook, etc. Tony and I actually wrote a paper about this subject and the comparative aspects on it between the US and Europe while at Stanford. I'm strongly in favor of those protections because it's what's going to allow the internet to work. Here, this is a bit different, right? Because these intermediary rules typically protect intermediaries if they take a hands-off approach. Third-party content being posted to your platform can't really supervise it at scale. Here, the assertion is that data was passed between these two entities, and there's a question around the intentionality and what Facebook was going to do with that. And this is in itself a very interesting problem if you think about how more and more these larger platforms that are emerging are exchanging data. Once you go beyond the simple web scraper and you start exchanging data through APIs, application programming interfaces, you kind of get a certain degree of control through code of how that data transfer happens, what data is being transferred, and then to your terms of use underpinning the API, what the allowed usages of that data are. So now I have no insight in any contractual agreement between Hulu and Facebook, but what I do think is that it's kind of interesting to think about these data flows as something that's potentially that can be regulated by code, and this is going back to the code is law team, which of course comes from Lessig originally, and this idea that maybe the APIs that Facebook and Hulu use to interface with each other in the future could embed these rules and have appropriate consumer protections built into them. I mean, all in all, I think it's a scary future where so many data points about our life, our location, can be put together, and you can build an extremely detailed profile of a person. I mean, your cell phone is the very best example. The kind of stuff you can do with pattern matching, and basically, I don't know who you are, but I know where you move every day. We had a super interesting talk at Stanford about this topic, where basically law enforcement can track gangs that use throwaway phones just based on patterns in how cell phones connect to cell phone towers. So I think this Facebook Hulu example is just like, it's the new world we live in, and it's getting more and more problematic as we add more and more sensors to our world that allow gathering of information and basically bringing it together in ways that are unprecedented. So I think this is scary. Don't know enough about the facts of the case to really comment in that, but right. But I see this as an increasing problem, and it makes me feel uncomfortable.
Let me spin this more towards something that you two do have knowledge and facts about, and that is LawGives, which is a digital means of connecting lawyers and clients. Traditionally, how that might have been done is, someone shows up at or calls a law firm, does a little searching, gets a referral, and starts talking to a lawyer. But now you guys find yourself in that intermediary position of gathering a bit of information from a would-be client so that you can match them with the right lawyer. And I'm sure you guys have had some interesting discussions about how to manage that data. Can you share your approach toward that with us, Tony?
Certainly. I think one of the first things that we were very aware of was the fact that we were handling potentially very sensitive information. And so the frameworks around any potential sharing of that information, both with the lawyers and, if in the future we were to have, handoffs to other services that lawyers are using, I think, we've been very careful to frame that around a design principle that is all about consent, and understandable consent as well. I think at the end of the day, sharing of information when it's with the full knowledge and consent of the person whose personal information is being shared, I think that can have a lot of beneficial uses where it's clearly of value to that individual to have the right people looking at this information and providing them with services on that basis. But I think where it is dangerous and scary, as Peter's saying, is where that is done pretty much without your knowledge, or the legalities under which that's done is in some way buried, within a terms of use which everybody's just clicking through. I think some of the things that we've been careful to include within the law gives framework is there's upfront anonymity when you submit an inquiry, so that the legal providers who are initially responding to your inquiry don't know who you are, and it's very much within your control as and when you choose to reach out to a provider and actually share your identity information. I mean, that's a design principle that is embedded within our technology. Likewise, with our terms of use, we've made an effort to provide a simple overview with regards to each of the clauses, especially around the privacy policy. And I think going forwards, as we look to the future where we ourselves start opening up our APIs for interactions with other technology tools and services, I think we are going to be doing so with a very careful intention around getting the right kinds of consents and fine-grained consents. Not just who you are going to share it with, but what is the purpose with which you are going to share this, around which this data is going to be used going forwards. And I think those are the best practices which are starting to come into play around certain standards that are coming into sort of broader use. There's sort of identity frameworks and data sharing frameworks such as OpenID Connect, which are becoming more standardized across different technology providers around this notion of both authenticating as who you say you are, but also what kinds of data can be shared with your consent. And I think because of issues like this, cases like this, Sarah, I mean, like you said, this seems so counter to what we would sort of assume to be the case, where I think the line in particular from that article, the user's identity and that of the video material were transmitted separately, albeit simultaneously. I mean, this notion that the fact that they were transmitted at the same time, but they're separate. You can't put them together. And the analogy was that it's sort of akin to giving a receipt to somebody and then giving a separate receipt to them, and that those wouldn't be put together. I think that is. I mean, it stretches the boundaries of actually what is actually happening within these corporations. And I think because of that danger, I think having these much more secure frameworks in place around obtaining consent and making sure that the user, the identity and their data is protected, I think that is going to be crucial going forwards.
Yeah, that's great to hear that you guys are so out in front of those privacy issues and thinking about them in such fine-grained and sophisticated terms. So kudos to you. We're going to move on to our tip and resource of the week. In our tips of the week, we're on a bit of a theme since if you haven't gotten the memo yet, we do have the wonderful resource of Sarah Pearson with us, who is Senior Counsel at Creative Commons. And so we've been taking the tip segment to help you understand a little bit more about Creative Commons. The tip that we'd like to offer this week is so that Creative Commons exists, say, and you'd like to use some Creative Commons licensed materials in something that you're creating. Sarah, how would you go about finding such materials?
Good. So there are a lot of different ways to go about it. One is to use Creative Commons' own search function on our site, which basically uses other people's search engines to search for CC licensed material. You can also go to, nearly, not all, but nearly all of the platforms that actually integrate Creative Commons licensing have CC search filters For example, on Vimeo, you can search for CC licensed videos. On Flickr, you can run searches for CC licensed images. And you can even filter down by what particular license you're looking for. I think on Flickr, they separate it by commercial use or not, or that sort of thing. So, and that's the case with most platforms, I think, that integrate CC licensing. As far as public domain content, there are lots of resources for public domain content. One of the best is, of course, the Internet Archive. There's also Europeana, Google Books. Now, and actually just to tie a bow on what we were talking about last week about SpaceX and the public domain issues with CC0, that actually was a great impetus for Creative Commons to finally push Flickr to adopt CC0 on its platform. And so now they offer, I think as of Monday, they offer the option to use CC0 or the public domain mark. And so the SpaceX images are now listed as public domain, even on Flickr. And I think I saw a tweet yesterday that said there were already 86,000 public domain images on Flickr just from the past 3 days that it's been an option. So it's pretty cool. So that's another great resource for finding public domain images right on Flickr.
Oh, that's fantastic and great news. All right, we have a couple of resources of the week for you. One of them is, we referenced Codex earlier in the show. This is a conference coming up at Stanford. It's going to be on April 30th. So if you find yourself in the Northern California area, it is a great way to explore legal informatics and the technological side of the law. Anything you guys want to add to the upcoming Codex event that we're plugging? Will you be there?
We're absolutely going to be there. I mean, it's been a deep pleasure for Tony and myself to have been here now for a couple of years and to see this community grow. And Codex has really been an accelerator in that respect. There's a lot of exciting projects that are lawyer and student driven that are coming out of the center, and it's also becoming a meeting point for other legal technology founders. So absolutely, if you are able to attend in person, stop by. Tony and I also typically live tweet these events, so you can follow us at LawGives, at Digital Lawyer, and at Law for the latest while it's in progress. We think it's going to be very exciting.
And the name of the conference is Future Law. Codex is the overarching organization putting it on. So that sounds like it'll be really great. And we look forward to your live tweets from there for those of us who won't be able to make it. We have one more resource for you that someone sent my way and I thought was really interesting. It's called We Consent, and you can find it at weconsentlive.com. And it has two aspects to it. There are two apps that We Consent is putting out. The problem that We Consent is trying to solve is to make communications about consent clear. And so they have a no app and a yes app, and they function in two very different ways. The no app is for the situation where you're receiving a text that is suggestive and unwelcome and maybe offensive, and you want to definitively tell this person no. Well, the no app will help you do that. And it records a video of the person watching the no message so that you know that they got it. And it encrypts that message first to the cloud and then to servers, and it survives for 7 years. So if there's any question about whether there was consent, you're going to have a definitive no there. And now the Yes app, which is even in some ways more useful and interesting, and it's maybe a look into the future about how we're going to form contracts about things. This is, again, in sort of the relationship context. And the Yes app is supposed to be It takes, they say, 20 seconds to use and creates a 7-year encrypted record available only to law enforcement upon judicial order of people consenting to be with one another. So that if there were ever a misunderstanding on that front, law enforcement could access and see, oh, yes, here there was consent, and here's the person on video confirming that. So I thought this was just really fascinating, not just because it's good to have definitive yeses and nos in that context, but extrapolating out to, wow, what an interesting way for people to express their consent or lack of consent in other contexts. What do you think about this, Tony?
Well, I'm just picking up off something in the IRC. My yes doesn't mean yes for 7 years, bro. I mean, that's a really important point.
Yes.
Even though you sign, even though you say yes, I mean, they kind of imply you can't change your mind. And I think the important thing to note is, yes doesn't mean yes forever, and like everybody always has the right to change their mind. What I think is great about these apps, though, is raising awareness that this is something that living today within the communities and in a more connected world, we do need to be aware of have empathy around somebody else's reaction to what you're doing at any particular moment. There was a great analogy that I think that was making the rounds of the internet around comparing it to having tea. The fact that you wanted tea, a cup of tea at 7 o'clock doesn't mean that you want a cup of tea at 10 o'clock, and you certainly shouldn't be forcing a cup of tea down someone's throat. And I think, just having that sort of cultural framework, being developed is the most important thing. And I think, these apps hopefully will serve a purpose to sort of bring that top of mind when people are thinking about their interactions, and certainly it's a very important issue that's getting a lot of deserved attention this year and right now.
Right.
Tony says it so well. I confidentially heard that 3 days ago that Tinder is actually going to acquire the Yes No app for $10 billion.
Bing, bing, bing. Yes, a logical marriage indeed of those two things. Sarah, any thoughts on this?
I mean, I'm very skeptical of this. Not only would your consent not last for 7 years, it might not even last for 5 minutes. It just depends on, you have your consent should be just, could change at any time. I mean, except after the fact, obviously, and that's what this is probably designed to prevent. But I'm skeptical. But it's interesting, and I'm surprised it's not an April Fool's joke. Actually, I kind of would have thought it was, but
yeah, no, it's not. I got this well before April Fool's, and I do think it's an interesting notion that people might, as their copy reads, in this confused and confusing environment, what is needed is a way for affirmative consent to be safely recorded and stored as potential exculpatory evidence. I could see, people deciding in a civil contractual kind of way that, hey, we don't need lawyers. We don't need a lot of legalese. We'll just record ourselves. It's sort of like that napkin that somebody jotted down the deal terms on that comes out and gets tossed in front of the jury as evidence. Instead of the napkin, this is the new napkin. You've got your app and people recording each other saying the terms of whatever it is they're agreeing to. And I'm just wondering, it's kind of a logical step from the fact that we all carry around devices capable of recording ourselves. I wonder if this is something that we'll start to see more in court.
There's some issues around the user experience with this app, but I think it's very promising if we think about initiatives like Google Glass and Microsoft's more recent announcement, HoloLens. What happens when I'm actually, I can overlay information in my vision? Will I, instead of launching the Yes No app, will I maybe swipe a person to the left to indicate my no, right? I think with new kinds of interfaces, it becomes a bit more realistic to have, setting the funny aspect of this app aside, to have legally binding interactions that don't take the effort of writing on a napkin.
Right. And now I have an image of two people, each wearing their respective Google Glass, starting to become intimate with one another and needing to, push a particular button or run a particular app before things get proceed further. Okay. So on that note, I think we will go ahead and wrap up this show. Thank you so much, Tony and Pieter from LawGives, Tony Lai and Pieter Gunst, the founders of LawGives. It seems like an amazing company. You guys are brilliant and wonderful and innovative and smart, and we're so glad that you could take the time to join us today. We wish you all the luck in the world.
Thank you. Follow us on Twitter. We have a very big announcement that's coming towards the end of this month. And yeah, we do this with passion, and we'll do it for many more years. Thank you for having us.
Great. Wonderful to get the chance to chat with you. I hope we can do so again. Obviously, there's lots more we could discuss, but at some point we have to bring the show in for a landing. So we'll go ahead and just let folks know that you should get in touch with us between the shows. You can email Sarah. She's sarahp@twit.tv. I'm Denise at twit.tv. You can find us on Twitter or Facebook or Google+. Just let us know, what you've thought of the shows, the issues that we've discussed, what you think we should be talking about, guests we should invite on the show. We love to hear from you. We love your feedback, and honestly could not do the show without all of your suggestions and help and support. So please keep them coming. What else? If you've been watching with us here on Friday morning, we start the show at Friday, 11 o'clock Pacific time, 1800 UTC. Each and every Friday except next week, we're going to be dark. So just to give you a heads up that we'll be taking a break next week. We'll be back at it after that, however. And if you're not able to join us live, that's quite all right, because you can find our archive of shows at twit.tv/TWiL and on YouTube and on Roku and in iTunes. And if you go to that twit.tv/TWiL page, you'll find all the various ways that you can take in the show in the way that makes the most sense for you from a convenience and time standpoint. We have just so much enjoyed the conversation, really learned some interesting stuff today, and great things to think about. We've been so glad that you could join us, and we'll see you the next time on This Week in Law. Take care.